Swayam Prabha. Digital India. Educated India.
Hello everyone, welcome to the fifth lecture on the course on law of copyright, patent, trademark and other IP. In the previous lecture, we were talking about authorship, ownership and transfer of copyright. I mentioned that there are two clear methods of transfer of copyright. One is individual administration, the other is collective administration through copyright societies. We will talk about copyright societies later on. We discussed individual administration, which is done either by assignment, section 18, or license, voluntary license, section 30, and we discussed the scheme of compulsory license which we have in our Act from section 31, 31 capital A and 32. I did not mention about one of the provisions of section 31 which talks about compulsory license for disabled people. We will refer to that aspect of compulsory license when we will discuss section 52, because this provision is there in 52 as well as 31. So, we will talk about it together when we will discuss section 52. So, we have understood what are the subject matter, what are the rights with respect to different subject matter, who will own those rights, what are the means to transfer those rights, and now we will understand what are the instances of infringement. When can you say that the copyright is infringed? The infringement of copyright is there in section 51, but before we refer to section 51, let us see what Supreme Court says about infringement of copyright, which you have in the case of R.G. Anand versus Deluxe Films. This happens to be the most important case on infringement. This tells you the test to determine infringement, and this is generally the guideline which we have to understand the scope of section 51. And you have to go through these 6-7 points to understand the subject. I have already mentioned that copyright is not concerned with ideas, copyright is concerned with expression of those ideas. So, what you have here is, if you see, there is no copyright on idea. There is no copyright on subject matter as such. It is the expression of that subject matter which deserves copyright. There is no protection on theme of the novel, plots, facts, howsoever historical or those legendary those facts may be. There is no copyright on these. So, there is no copyright on idea, subject matter, theme, plot, facts, and in case there is a case of violation of copyright, the courts have to confine to see whether what has been copied is the form, the manner and the expression of the ideas and not the ideas themselves. So, this point explains that idea is not the subject matter of copyright, the expression of idea is the subject matter of copyright. You can call this as abstraction. This is abstraction. I will explain why I am saying this is abstraction later on. So, in any work you have to abstract the work into its constituent parts and be very clear that only the expression of idea is protected, not the idea itself. The second point, you see, court says when the same idea is being developed in different manner, it is manifest that source being common, similarities are bound to occur. So, when two of us are deriving some work from the same source, similarity is bound to occur. In that case, the responsibility of court is not to look at the similarity of idea, but to look at the similarity on fundamental aspects of expression of the idea. If I am making a television serial on the epic Ramayana, you are making a television serial on the epic Ramayana, then similarities will definitely be there. Similarity of content, similarity of sequences, similarity of idea. Court will not have to look into the similarity of the content as such. Court will have to look at the similarity of the manner in which we express the same idea. The third point, this is important, court says one of the surest and safest tests to determine violation of copyright, you see, one of the surest and safest tests to determine violation of copyright is to see if the reader, spectator or the viewer, after having read or seen both the works, is clearly of the opinion and forms an unmistakable impression that the subsequent work appears to be copy of the original work, then infringement is said to have been proved. This test may be called as look and feel test. It may also be called as lay observer test. What is the test? You talk to a lay observer, someone who has read the book, someone who must have seen the movie, and then ask whether in totality of circumstances you make an unmistakable impression that the subsequent work appears to be copy of the original work. If the answer is yes, the infringement is said to have been proved. You can write the word comparison here. I will explain why I am using these words, abstraction here and comparison here. So, no copyright in an idea, copyright subsists in expression. Second, when the source is same, similarities are bound to occur. A responsibility of the court is look at the fundamental and essential aspects of expression. Third, this is important, one of the surest and safest tests to determine violation of copyright is look and feel test, lay observer test. You talk to the viewer, spectator and ask whether in totality of circumstances he makes an unmistakable impression that the subsequent work appears to be a copy of first, then in that case infringement is said to have been proved. Point number 4, where the theme is the same but it is treated differently, presented differently, so differently that the subsequent work becomes completely new work. I am making a cinema based on the theme on which you have made a cinema, but my treatment is entirely different to the extent that my work becomes an entirely new work, my cinema becomes an entirely new cinema, then no infringement of copyright takes place. Next point, point number 5, where apart from similarities, there are material and broad dissimilarities. Where apart from similarities, there are material and broad dissimilarities, which negate the intention on the part of defendant to copy plaintiff's work. There may be similarity. Be very clear that copying is not bad in copyright law. Mere similarity is not the proof that you must have copied. There may be many reasons for similarity. One reason can be source is same. So, mere similarity between the two works will not lead to the conclusion that copying has happened. The court will also have to look into the broad dissimilarities, and if these broad dissimilarities negate the intention on the part of defendant to copy plaintiff's work, no infringement is proved. The last point talks about infringement by changing the form. You see, generally we can infringe a work by two methods. You have written a novel, I have taken few pages from your novel. This is infringement by taking a part. You have written a novel, I have made a cinema based on your novel. This is infringement by changing the form. Court says in a case of infringement by changing the form, the task of plaintiff to prove infringement is difficult because you see in cinema, the canvas is very broad. You can add new characters. You can change the background, the color. And by changing all these, you can change the complexion of the cinema. So, the task of plaintiff to prove infringement is difficult, but still the test remains the same. The test is test of a lay observer, the look and feel test. A lay observer will be asked, you read the novel, you watch the cinema and then tell us whether the cinema appears to be a copy of the novel. If he says yes, infringement is said to have been proved. So, these are few points which explain the idea of infringement in India. No copyright in idea. If the source is same, similarities will definitely be there. The safest test is look and feel test. If the treatment is different and a new work comes into existence, no infringement takes place. Don't only look at the similarities, you must also look at the material and broad dissimilarities. If those dissimilarities negate the intention on the part of defendant to copy, it is not a case of infringement. And the final point, even in case of infringement by changing the form, there is this test called as test of look and feel, which has to be applied. Now, this chart will help you in understanding the scheme which we are going to discuss. Infringement can be of two kinds: primary infringement, secondary infringement. In primary infringement means when you are actually making copies, you are actually infringing somebody's work. Secondary infringement is a situation when you are yourself not making copies. When you are yourself not making copies, you are facilitating copying, or you are dealing in infringing copies. So, primary infringement is when you are actually infringing, when you are actually doing which act which is exclusively reserved for the owner of copyright without his permission. And secondary infringement is when you are either facilitating copying, you are providing means to copy, you are providing platform to commit infringement, or you are dealing in infringing copies, you are selling infringing copies. Infringing copy is defined in section 2M. You can refer to section 2M. Infringing copy is also defined in explanation to section 51. You can refer to these two provisions to understand the meaning of infringing copy. I may refer to it maybe. So, therefore, infringement is of two kinds: primary infringement, secondary infringement. Primary infringement is a situation where the person is himself committing infringement, performing any act which is exclusively reserved for the owner of copyright. Secondary infringement can be of two kinds. One is when you are facilitating copying, you are not doing it yourself, you are providing means. And the second is when you are dealing in infringing copies, when you are selling infringing copies, you are giving infringing copies on hire. Now, come to first, primary infringement. As I said, this is an act. A defendant is doing activities which are restricted activities. What are the activities which are restricted for others? Those activities which can only be performed by the owner of copyright. What are those activities which can be performed only by the owner of copyright? We have discussed those activities in section 14. Only the owner can reproduce, only owner can distribute, publicly perform, broadcast, adapt. So, all those activities can be performed by the owner, and these are restricted activities for others. So, if you make copy without the authorization of owner, you are committing primary infringement. I just said that similarity in itself will not lead to the conclusion that copying has happened. Similarity may be because of various regions. One region may be copying, the other region may be similar source. So, before deciding whether it is the result of copying, we have to understand something called as causal connection. In an exam situation, when two students are sitting next to each other and the answer scripts are identical, one may lead to a conclusion. One may come to the conclusion that similarity is because of copying. But in a situation where one student is in one room, the other student is in other room, they never had access to each other's work, never had opportunity to copy each other's work, still the two scripts are identical. What does it mean? Does it mean the similarity is because of copying? No. So, whether similarity is because of copying or not is to be determined with the help of something called as causal connection. And in causal connection, I use two terms: access to plaintiff's work and opportunity to copy plaintiff's work. Now, in Copyright Act, what happens is, if I am filing a case of infringement of copyright, I will have to only prima facie, I will have to establish prima facie similarity between my work and defendant's work. If my music is same as defendant's music, I will only argue that there is prima facie similarity. Once I establish prima facie similarity, the burden shifts on to the defendant to prove that similarity is not because of copying. And how will he prove that similarity is not because of copying? By proving absence of causal connection. He will prove that he never had access to my work, he will prove that he never had opportunity to copy my work. And copying can be of many kinds: direct copying, indirect copying. I make a two-dimensional drawing of a pipe, for example. I make a two-dimensional drawing of a pipe. You followed the drawing and made a three-dimensional pipe. This is direct copying. Now, a third person followed that three-dimensional pipe and made a drawing of two-dimensional pipe. He is copying two things. He is directly copying the pipe, three-dimensional pipe, and he is indirectly copying my diagram. So, copying can be mediate, immediate, direct, indirect. If you had access to that three-dimensional pipe and had opportunity to copy that three-dimensional pipe, it means you also had access to the drawing on which the pipe was based. So, it is a case of indirect copying or mediate copying. So, all that has to be disproved by the defendant. He will have to prove that copying is not the result of similarity, and he will be able to prove it by way of proving absence of causal connection. But if he fails to prove, and if copying is established, then we come to the next stage of our inquiry. Before looking at what defendant has done, we will have to see what is the plaintiff's work which is alleged to have been infringed. Because, for example, if this is the plaintiff's work and this much is copied, out of the copied portion, it is possible that this much portion is not original. So, the case is copying of this much from this work. That means, before examining what defendant has done, whether that amounts to infringement or not, we will have to understand what is the plaintiff's work. And to understand what is the plaintiff's work, we have certain things which we have to understand: parameter, depth of protection, dissection of the work into protected, non-protected part. We will dissect the plaintiff's work into protected, non-protected part on the basis of relevance, originality, non-protection of idea. I will explain these points. Once it is established that out of this work, this much is not original, this is idea, we are left with a small portion of plaintiff's work, out of which this much has been copied by the defendant. So, once what is the plaintiff's work is clearly identified, then comes the stage of what defendant has done, whether what he has done is substantial copying or not. Copying can be identical, copying can be non-identical. Identical copy is simple to decide, it is always infringement, you copied whole of it. Non-identical copying can be done by two methods. I already explained it in my previous session. It can be done by taking a part, it can be done by changing the form. Whether in a given case the copy amounts to infringement or not is what we have to discuss. So, primary and secondary. Primary first. Primary means you are doing some activities which are restricted. There is similarity between plaintiff's work, defendant's work. That similarity is because of copying. Let us see what is the plaintiff's work. Once we identify what is the plaintiff's work, then we will see what the defendant has done amounts to infringement or not. Coming to the differences between primary and secondary infringement, I am sure by now you have understood it. Primary infringement is an act of infringement which the infringer is doing himself. It is one of those restricted activities which the infringer is performing. And I have already mentioned the list of restricted activities is there in section 14. So, if I have called as right to broadcast, then only if any third person is broadcasting my work, I can say you are infringing my copyright. If I do not have a right to broadcast, then anybody will broadcast it, I cannot say you are violating my right. So, whether your act amounts to primary infringement or not, that depends on scope of protection. My rights, my scope of protection will decide whether your act amounts to infringement or not. So, primary infringement relates to scope of protection. Primary infringement relates to scope of protection. Why I am saying so? Because it is only when I have a right that I can stop you from performing those acts. So the extent of rights which I have in 14 will decide whether your act is infringement or not. So primary infringement relates to scope of protection. Secondary infringement relates to commercial context. It relates to commercial context. I said secondary infringement, there are two things. One is when you are facilitating copying. You yourself is not infringing, you are providing means. Second, you are dealing in infringing copy, you are selling infringing copies, giving infringing copies on hire. So you are doing all these things for some profit motive. There is some financial consideration involved. There is some market involved. And that is why I said secondary infringement relates to commercial context. So primary infringement relates to scope of protection. Secondary infringement relates to commercial context. The second difference is in terms of state of mind. Primary infringement is based on the notion of strict liability. Once you have performed one of those restricted activities, you have committed infringement. An absence of intention or lack of knowledge is no defense. You cannot say that, my lord, I was unaware that I am infringing. That is not acceptable. It is based on strict liability principle. Whereas in case of secondary infringement, you always have this excuse of absence of knowledge. You can always say that I had no reasonable ground to believe that I am infringing somebody's copyright or I am facilitating infringement. So this is the second point of difference. Primary infringement is based on strict liability. Secondary infringement is a situation where you can claim the defense of absence of knowledge. So absence of knowledge is a good defense in secondary infringement. So with this background, now we can read what is there in section 51. Let me again take you back to the chart which I presented. Infringement can be primary infringement, secondary infringement. Primary infringement, you have to prove that the activities which are reserved for owner have been performed by somebody without the permission of the owner. You establish the causal connection in the sense that you establish that defendant had access to your work, he had opportunity to copy. And then court will examine what is the plaintiff's work which has been copied. And then finally, court will examine what the defendant has done, whether it amounts to infringement or not. I have already mentioned secondary infringement may mean facilitating copying or dealing in infringing copies. The meaning of infringing copy is there in section 2M. It is there in explanation to section 51. Now let us see what is there in section 51. It does not define infringement. It does not define infringement. It gives me instances of infringement, when infringement takes place. It says copyright in a work shall be deemed to be infringed when any person without the license granted by the owner or by the license of registrar or in contravention of any of the license granted does anything the exclusive right to do which is by this act conferred upon the owner of the copyright. So you are doing anything which is exclusively reserved for the owner. What are the things reserved for the owner? Section 14. So 51A1 talks about primary infringement. It talks about primary infringement, where you are actually infringing somebody's copyright. You are actually performing an act which is exclusively reserved for the owner of copyright. Anybody without permission, without license of the owner or without license of the registrar of copyright permits for profit. There is a commercial context you can see. I mentioned in the previous slide that the difference between primary and secondary infringement is secondary infringement relates to commercial context. So you are or I am permitting for profit what? Any place to be used for infringement. So I am facilitating infringement. I am permitting a place to be used for infringing activities. I am facilitating infringement unless he was aware and had no reasonable ground for believing that he is facilitating infringement. This is secondary infringement. Secondary infringement, you are facilitating infringement for profit purpose, and here you have the element of knowledge. absence of knowledge is a good defense in secondary infringement. Clause B talks about the other form of secondary infringement which I mentioned, where you are dealing in infringing copy. You are selling infringing copies, giving infringing copies on hire, you are distributing infringing copies, you are exhibiting in public infringing copies, and you are importing into India infringing copies of the work. So, this much is secondary infringement and 51A1 is primary infringement. So, this is what I explained you with the help of that chart. 51 talks about in clause A, point number 1, it talks about primary infringement, point number 2, and clause B talks about secondary infringement. Okay, going back to the chart once again, we have understood what are the restricted activities, we have understood about causal connection. Now, we will see what is the plaintiff's work, because I have already mentioned that out of the entire work which plaintiff claims to be his work, he may be author of a limited part. So, how will you decide what is the plaintiff's work? We have three things: parameter, depth and dissection. We will understand these three now. What is the work which is alleged to have been infringed? Because an author may claim, see, there is a book of 10 chapters and I have copied one chapter from that book. Whether one chapter from a book of 10 chapter amounts to infringement or not, whether it amounts to substantial copying or not, author may claim that all the chapters are separate copyright. And if all the chapters are separate copyright, copying one chapter would mean copying the entire work, one full work. So, therefore, we will have to first of all understand whether one work is one copyright or n number of copyrights. And how will we decide? We have to find out a parameter. And the parameter is, if the portion of a work has got meaningful independent existence, that portion may be considered as a separate copyright. So, therefore, if there are two parts which may have independent existence, can be sold independently, then the work in question can be considered as two copyright. And it is useful if I can prove that this work is actually two works and you have copied this much, then copying this much from this work may not amount to infringement, but copying this much with respect to this work may definitely amount to infringement. So, therefore, authors will tend to argue that they have many copyrights in one work, and we have to decide it on the basis of the parameter called as, if a particular aspect of a large work can have meaningful independent existence, it may be considered as a separate copyright. First. Second word is depth of protection. A simple statement can be in relation to works, literary, artistic, dramatic, musical works. The protection is deeper, whereas in case of entrepreneurial works like cinema and sound recording, the protection is very superficial. I have explained this point while discussing section 14. Only the fact of recording is protected in favor of owner of copyright in cinema and sound recording. So, this is one point which I wanted to convey, that you have slightly deeper protection in works other than entrepreneurial works. But I also want to explain another point. Copyright is what? It is different levels of abstraction. For example, when you open a book, what do you see? You see words. You don't straight away see the story. You see the words. So, at most abstract level, you have words. You stay with that page, you see sentences. You see sentences. You further stay with the page, you see paragraphs. You continue reading the novel. You will form the characters in your mind, you will form the story in your mind, the theme, the plot, all this comes to your mind. You don't see the characters on the page. Now, one way to distinguish idea from expression is, whatever you see when you open the book is expression, and whatever you form here in your mind is idea. Therefore, characters are ideas. You cannot claim copyright on characters. Story is idea. theme, plot, these are ideas because you form these here in your mind. So, anything which you form here is idea, whatever you see on the page is expression. That is idea expression dichotomy. What copyright protects? Expression. What is not protected? The things which you form here. Characters are ideas. Now, you must have experienced that when you start reading a novel, it is not very interesting to read initial few pages. Authors usually devote not many pages on explaining the characters in great detail. Why do they spend a lot of pages? Because they want to explain characters in such great detail that lifting the character alone will not be possible. Copying the character alone will not be possible. A part of expression will also come along with it. For example, if you want to copy the character of Spider-Man, you will not be able to successfully copy that character unless you copy the mannerism of Spider-Man, the dress of the Spider-Man. All that mannerism, attire, all that is part of expression. So, therefore, why do authors spend a lot of time in explaining characters? So that character gets embedded in expression and lifting the character alone becomes impossible. So, a detailed description means deeper protection, even the idea gets protected to some extent. That is what I mean to say depth of protection. So, in every case, for example, if I copied the character of Spider-Man, you cannot simply say, the court cannot simply say that it is only a copying of character and therefore it is not infringement. No. Look at the novel, see whether the character gets embedded in expression or not, see whether it is a deeper protection or not. If it is deeper protection, then you will end up protecting the idea also in a given case. So, before examining what defendant has done, you will have to first of all examine what is the work which has been infringed. There may be a situation where ideas may get embedded in expression, and that is a situation where to some extent even idea get protection. The third thing is dissecting the work between protected and non-protected parts. Dissecting the work between protected and non-protected parts, there are three tools I have mentioned. One is relevance. You have all these points in that chart also. You dissect on the basis of relevance, you dissect on the basis of originality, you dissect on the basis of non-protection of idea. Relevance means relevant labor. Only that aspect of a work is protected which is the result of application of relevant labor. So, for example, in a computer program, I mentioned it while discussing section 13 that computer program is included in the definition of literary work 2O. But you must be familiar that in computer program, much of the program is written in the form of syntax, codes which are not purely literary in nature. So, those aspects of the computer program will not get protection because only that part will get protection which is the result of application of literary labor, relevant labor. So, you dissect the work into that portion which is the result of literary labor and that portion which is the result of non-literary labor. The part which is the result of non-literary labor, if that is copied, it is not infringement. Second method of dissecting the work into protected, non-protected part is on the basis of originality. Only the original part is protected. So, you have copied something from my work which I myself copied it from somebody else. Can I claim infringement of copyright? No. There is a case which I have mentioned here, Land Transport Safety Authority of New Zealand versus Glogo 1991. Court says the part which is more original will get better protection as compared to part which is less original. More original, less original, we have understood the meaning of originality. If you apply more labor, the portion in question becomes more original. If you apply less labor, it is less original. So, therefore, part which is original has to be differentiated from the part which is non-original. And if non-original part is copied by the defendant, it is not infringement. The third thing is idea expression dichotomy. Idea expression dichotomy. You have this case called as Computer Associates versus Computer Associates versus 1993. This is American decision. in which the issue was that defendant copied some portion from plaintiff's computer program, and in fact the interface has been copied. This interface happens to be the result of artistic labor, it is not the result of literary labor. Whether it amounts to infringement or not, court invented a test called as AFC test. AFC test is abstraction, filtration, comparison. Court says take both the computer programs, abstract the computer programs into its constituent parts. Second stage is filtration, remove out unprotected parts, and then comes the stage of comparison. Then compare the remaining portion to see whether it is infringement or not. How will you remove unprotected parts? You will remove those parts which is the result of application of non-relevant labor. You will remove those parts which are non-original. You will remove those parts which are only idea. Filter out those unprotected parts. You are left with only the protected portion of plaintiff's work. Then make a comparison between plaintiff's computer program and defendant's computer program. There is a doctrine called as doctrine of merger. If there is an idea which can be expressed in only one way, if there is a unique expression possible, then expression is also the idea. If there is an idea which can be expressed only by one method, then giving protection on that expression would mean even idea is protected, because there is no other expression possible. That is a situation when idea merges with expression, and even such expressions have to be filtered out. So while filtration you will apply doctrine of merger also. Doctrine of merger means when there is only one expression possible for an idea, even the expression merges with idea and is filtered out. So this is what we have to do with respect to plaintiff's work. Now if I go back to what we discussed in R.G. Anand, I said the first point is abstraction. You divide the work into its constituent parts. The third point is comparison, look and feel test. What I am trying to say, in case tomorrow there is a case on violation of copyright in computer program, we only have this option of applying the test of R.G. Anand. When we will look into R.G. Anand, out of 3 points, that is AFC, we already have the points of A and C. The only thing which is missing is filtration. That has to be supplemented. So we are partly ready by virtue of R.G. Anand case to decide even cases of infringement of copyright. Therefore, I wrote these words here, which we see in the test called as AFC. So this is how you first of all characterize what is the work. Once we understand what is protected, once we have understood that out of this plaintiff's work, this much is not original, this is because of non-relevant labor, this is idea, so therefore what is protected? Only this much is protected. And if defendant has copied this portion, that means he has copied only this much from the protected part. Now we can decide whether copying of this portion from the protected part amounts to infringement or not. Let's see what the defendant has done now. Defendant has copied plaintiff's work. Identical copying, non-identical copying. Identical copying is a simple case to decide. Non-identical copying can be done by two ways. By taking a discrete part, as I have been mentioning, by taking a discrete part or by changing the form. These are the two methods by which you make a non-identical copy. When the discrete part is copied, let's take these two cases one by one. First is where a discrete part is copied. I have already mentioned that copying itself is not bad in law. We all are allowed to be inspired by others' works. We are allowed to prepare derivative works, derived works. We have the freedom to copy a portion from plaintiff's work. It is not that every work has to be a new work. But then what is prohibited is substantial copying. It is the substantial copying which amounts to infringement. So therefore, in a case of non-identical copying by taking a discrete part, the moot question, the key point is to decide whether copying is substantial copying or not. And how do we decide whether copying is substantial copying or not? There are various factors. Why did the defendant take that part? What was the purpose behind copying? This is the first point. Second, the relationship between the parties, the relationship between plaintiff and defendant. If plaintiff and defendant are competitors in marketplace, then the chances of copying being called substantial copying is high. But if the parties are unconnected, then chances of copying being called substantial copying will be low. So what is the relationship? Next important point is, what is the nature of the work? Is it a fiction or an information based work? Because you see, factual descriptions will get better protection as compared to fiction. So if defendant has copied from fiction, the chances of being called substantial copying will definitely be low as compared to the situation where he is copying from a work which is information based, which is factual description. So why did I take that part? What is the relationship between plaintiff and defendant? What is the nature of that work? But the most important factor is to see whether the part which is copied is relatively important part of plaintiff's work or not. The portion which has been copied is relatively important portion of plaintiff's work or not. So what I am trying to see, we have understood that defendant is performing restricted activity, the causal connection is established, that defendant has access to my work, defendant had opportunity to copy my work, court has examined what exactly is my work on the basis of parameter, relevance, dissecting the work into protected, non-protected part on the basis of relevant labor, on the basis of originality, on the basis of non-protection of idea. After having done that, now court will see what the defendant has done is infringement or not. Defendant has copied the work. Copying can be identical, non-identical. Identical copying is simple case to decide, it is infringement definitely. Non-identical copying can be done by two methods, one by taking a discrete part, the other is by changing the form. And now we are talking about the first form, which is by copying a discrete part. As I already mentioned, copying itself is not bad in law, it is the substantial copying which makes it infringement. Whether in a given case the copying is substantial or not is to be decided on the basis of certain factors. Why did I take it? What is my relationship with plaintiff? What is the nature of the work? But the most important factor is the relative importance of the portion which is copied. And how do we decide relative importance of the portion? How do we decide relative importance of the portion? The part which I have copied is a relatively important part of plaintiff's work. How do I decide it? It's a question of fact. Yes, it's a question of fact. It's a matter of degree. In relation to technical subject matter, you can take help of expert evidence. You may call an expert to tell you whether the portion which has been copied is relatively important part of plaintiff's work or not. But you have to keep in mind that importance of the portion which has been copied must be judged from the standpoint of the person to whom the work is addressed. If it is an engineering diagram, then the relative importance of the portion which is copied is to be judged from the standpoint of an engineer. Third important observation is that the relative importance must be judged with respect to plaintiff's work and not with respect to defendant's work. What I am trying to say, the copied portion may constitute one page of a book of defendant consisting of 1000 pages. It may be a very minuscule percentage, but it may be 10% of plaintiff's work. even if it is not substantial with respect to defendant's work, the relative importance is to be judged with respect to plaintiff's work. It was an important part in plaintiff's work. So, call an expert. Second, examine importance with respect to the standpoint of the person to whom the work is addressed. Third, the relative importance is to be judged with respect to plaintiff's work. Fourth, the relative importance must be judged with respect to relevant labor. There may be an artistic work, I have applied entire paint on this side, there is only one or two dots here on this side, defendant has copied the dots. These dots may be very important to understand the psychology of the author, but these dots are not very important in terms of copyright law, because more labor is applied on that portion where I have applied more paint. So, relative importance is to be judged with respect to application of relevant labor. Substantiality does not only mean quality. So far what I have been saying, relatively important part. But there may be situations where the entire work may be relatively important. The entire work may be consistent in terms of quality. For example, in sound recording, in phonogram, what belongs to producer of phonogram? Only the recording, and the recording may remain same throughout. So, if the recording is same throughout, copying first 30 seconds will also amount to copying of important part, copying last 30 seconds will also amount to copying of important part. How will you decide whether copying is substantial copying or not? That has to be done on the basis of quantity alone. See what is the prevailing trade practice, allow that much of copying, not beyond that. Because the quality test cannot be applied here, because the quality of recording remains consistent throughout. There is another important point called as cumulative taking. Cumulative taking, for example, there is a book in your library consisting of 1000 pages. One student goes to the library, gets page number 1 photocopied. Is he committing infringement? No, because it is a very small percentage which he has copied. 0.1% is a very small percent which he has copied. So, today he did not commit infringement. Tomorrow he goes and gets page number 2 photocopied. Is he committing infringement? Tomorrow he copied only 0.1%. But he keeps on doing it, and in 1000 days he eventually gets the entire book photocopied. Did he commit infringement on any one of these days? But yes, if all the acts can be considered as one act, if all the acts put together can be considered as one act, it amounts to infringement the moment it became substantial. There is a thumb rule, which says that if no test is applied, if you are not in a position to apply any test, then you may allow a maximum of 10% of copying, not more than that. But this is a thumb rule which is to be applied in case you are unable to apply any of the tests which I have mentioned. So, we can safely say the moment he crossed 10%, he definitely committed infringement. But provided all the acts of copying is considered as one act. If all the acts of copying is considered as one act, then only you can say it is infringement. But if all the acts are 1000 acts, he never committed infringement. So, that is how courts will have to look into the cases of cumulative taking. These are the factors to decide whether the portion copied is relatively important portion. These are the factors to tell us whether the copying is substantial copying or not. So, what we have discussed so far is infringement by taking a discrete part. And if I take you back to the chart once again, we said primary infringement, secondary infringement. Primary is when you are doing identical copying, non-identical copying. Non-identical copying can be done by two methods: by taking a discrete part, by changing the form. So, we have discussed till this point taking a discrete part. The next way of committing infringement, the next way of doing non-identical copying is by changing the form of the work. When you convert a novel into cinema, when you convert the description two-dimensional circuit diagram into a three-dimensional actual circuit. When you convert the description given in a recipe book into a three-dimensional actual recipe, this is our what? Infringement by changing the form. There is an important observation of a 1995 case called as auto spin oil seals versus beehive spinning, where the court says it should be borne in mind that it is not enough to say that the defendant has used the claimant's work. As I have been saying, we all are free to use anybody's work, to create our work. There is an exception in favor of research. So, limited use is permitted. So, you cannot say that defendant has used plaintiff's work. That is not sufficient. He has to prove that the defendant has reproduced it. The court should ask the question, is it accurate to say that the alleged infringer's article is, from a common sense point of view, a reproduction of this particular type of literary work? What court wants to say here is that you have to apply common sense point of view to understand whether the defendant's work is copy of plaintiff's work, because here the form has been changed. What is the test? The test is common sense point of view. Go back to what we discussed in R.G. Anand. We said the last point of R.G. Anand, in case of infringement by changing the form, the task of plaintiff becomes difficult because cinema, for example, in cinema you can bring in new characters, change the background and the complexion will look different. Still the test is what? Common lay observer's test. The test is look and feel test. So, the observation of R.G. Anand is in line with what? Auto spin oil seals versus beehive spinning. So, the law in England, common sense approach. Law in India, lay observer approach. Both are same. Now, in relation to infringement by changing the form, 2 points are important. I just mentioned that if there is a two-dimensional description of a circuit and I follow the description, I make a three-dimensional circuit, a functional circuit. I am infringing by changing the form if I have done it without authorization. Similarly, if there is somebody's recipe written, I follow the instructions, I come out with a three-dimensional dish, whether this also amounts to infringement by changing the form. The common sense approach will say that in one case it is yes, in the other case, in recipe book case, it may not be infringement. Why? Why? Because in case of circuit description, you have very precise description. The descriptions are very specific. You have to have 1.5 volt cell, you have to have this much of resistance, you have to have copper wire, you have to have this much length of aluminum wire and so on. So, descriptions are so precise that anybody who will follow the instruction will end up making the same circuit. Whereas in case of recipe book, the descriptions are very vague. You have to fry something till it becomes brown. In my case, it always becomes black. So, the descriptions are very vague. Now, on the basis of these illustrations, I can tell you 2 points here. There is more protection for factual description as compared to non-factual description. Factual description, circuit diagram, non-factual description, the recipe book. Second, more specific is the description, more will be the protection. Specific description, circuit diagram. Non-specific description, recipe book. So, on the basis of these points, you will have to finally come to the conclusion whether by changing the form what you have done is infringement or not. And the test which you will be applying is same, the test of look and feel, the lay observer test. So, that is all in primary infringement. So, primary infringement relates to scope of protection, secondary infringement is commercial context. Secondary infringement is commercial context, and I have already mentioned that absence of knowledge is a good defense. There are two forms, one is providing means for making infringing copies, you see. I am supplying equipment to commit infringing activities. There was a case called as CBS Songs versus Amstrad, in which there is a company which introduced a double cassette deck feature. You can copy a cassette by using this deck feature, but they had a warning that certain recordings need permission of the owner. When the case of secondary infringement was filed, the manufacturer of that machine said that despite having this warning, we had no reason to believe that people will still commit infringement. So they were exempted from liability on the ground of absence of knowledge. This is a very important judgment, A&M versus Napster, where Napster created a website allowing users to share music files. Napster itself was not recording or reproducing the music files. The users were allowed to share music files using Napster. Court said it is a case of contributory infringement. It is a case of secondary infringement. There is financial consideration involved, and Napster had knowledge of peer-to-peer sharing of infringing files. I will request you to kindly read this judgment. It is of 2001. The second kind of secondary infringement is where you are dealing in infringing copies, you are importing, you are possessing infringing copy in the course of business, you are selling, giving it on hire, you are exhibiting. These are the instances of secondary infringement. So as I said, 51A1 talks about primary infringement, 51A2 and 51B talk about secondary infringement. But that is not all. You have a long list of activities which are exempted activities, and all these activities are there in section 52. These are those activities which are essentially infringing, but in public interest law exempts those activities from liability. So now, after discussing 51, in the next session we will be talking about that list of permitted activities which are there in section 52, which are list of exemptions. So that is all on the issue of infringement. Thank you very much for joining the session. Thank you.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar, and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.